Jenny Green from the Center for Constitutional Rights. Speak next.
I'm going to speak just briefly about several efforts CCR has been involved in to try and hold some of the torturers responsible for the U.S. detention facilities accountable. And I'm going to go chronologically. Shortly before the scandal broke in the press, we started getting reports about what was happening. And we also started getting reports about the role of two U.S. military contractors. It wasn't enough for U.S. officials to be involved in moving up to Donald Rumsfeld. But as people may have been following in the newspapers, the U.S. often farms out its dirty work, historical practice. In this case, two contractors, one providing translation services and another providing interrogation services. The Titan Corporation, which is based in San Diego, California, the Khaki Corporation, which is based in Arlington, Virginia. Those two companies were recruiting people. It seemed to be a premium if people had anti-Iraqi views. It would be more likely, not less likely, to be hired as a translator or an interrogator. So the operations of places like the Abu Ghraib detention facilities, if you listen to people's reports, they talk about the torture that was done by the soldiers and also by the interrogators. A lot of the abuse was also verbal, and when you're functioning in a foreign language, what exactly is the role of the translator? And the corporate defenses have been along the lines that you might expect. We were just the translators. We just did what the government told us to do. And we're now in the midst of fighting out whether that is in fact a defense. We brought the case in California, the home of the Titan Corporation, the larger of the two companies, in June 2004. Another case was filed in Washington, D.C., and that case was filed in Washington, D.C. because they said, a huge basis of this case was the conspiracy with U.S. government officials. Now, we don't disagree with that, but we felt that the larger of the two companies and in California, it was important to hold this company responsible for its role in this torture. And there were multiple participants in this, multiple pieces of this conspiracy, and the corporations can't just walk away and say the government needs to do it. So we are, we spent the first couple of years of the litigation fighting out where exactly the case would be heard. We're now back in D.C. And are dealing with very bad law in D.C. which basically says, well, you can't really sue a corporation for something which is an international law violation like war crimes and crimes against humanity. However, we have been allowed to proceed for our claims of state tort law, wrongful death, assault and battery, and basically we'll get them any which way we can, in terms of holding them accountable. There's also very strong law in the United States that international law can apply to those claims as well. So we're going to see if we can push that forward, saying universal standards. Universal means universal. The other thing which we're really fighting out right now is there such a thing as the government contractor defense? Can a corporation come in and say, the government said we should do this, therefore, and you can't sue them because of immunity in United States courts for U.S. government officials. So if you can't sue them, you can't sue us. So we're in this ironic position of saying, well, even if you can't sue the U.S. government officials, you still should be able to sue the corporation in the United States court, because that defense doesn't apply to these types of situations. Torture is illegal. The companies knew it was illegal. They can't hide behind this. Now, the CCR, of course, was not content just to say, okay, we'll sue the company and we'll let the government officials off the hook. But we said if we can't sue them in the United States, we will find a place we can sue them. So in 2005, we brought a case against Donald Rumsfeld and 4 other U.S. officials. We included Janice Karpinski at the time. And that case, well, it didn't last very long. Donald Rumsfeld wanted to go to Germany, so the German prosecutor said, well, can't really sue it here, so because of immunity laws, and he's, a citizen official. And besides that, there's this pending, and what they didn't, the most public part of what they said was, and there's this pending investigations in the United States, so we don't want to interfere with the efforts of accountability in the United States. So we, took the dismissal, tried to appeal it, appealed to the UN rapporteur for the independence of judges and lawyers because of, so much political influence had been applied to the German prosecutor. And then, kept collecting evidence and looking at all the reports that are coming out, none of them holding high-level officials accountable. I mean, to date, 11 junior U.S. soldiers have been prosecuted, and that's it. But no high-level officials. So on November 8th, Rumsfeld resigned. And just coincidentally, we had been planning to refile the German case in November. So on November 14th, we filed a renewed indictment and saying that, nothing's happening in the United States. No high-level officials are being prosecuted. Horrific violations like these need to be prosecuted. So we renewed the attempt there. If people are interested, they can go on to CCR's website, write a letter to the German prosecutor. There's even a letter in German you can sign on to urge the German prosecutor to do the right thing and really hold the U.S. officials accountable for what they did, in the detention facilities in Iraq. One of the other things that we mentioned to the German prosecutor is the recent passage of the Military Commissions Act, which was the law passed last fall, which denied habeas corpus for people at Guantanamo and also provided immunity for U.S. officials for their treatment and including torture of people in their detention, labeled enemy combatants. Some of the problems in that bill are the definitions of sexual violence, rape, and sexual assault. With the election of the new Congress, we're also trying to get that law amended so that that law does not create horrible precedent all over the world and undermine a lot of the work that international women's organizations have done, to expand those definitions. And those are just the things I wanted to touch upon. Thank you.
Thank you, Jenny. I just want to reiterate how important those legal efforts are, and also just to make a note, which is that in the case of the Iraqi women who have been detained, and we don't have clear statistical numbers even of how many people have been arrested or are in detention, but it's clearly up in the thousands. The vast majority of those women, certainly it's about women who've been arrested by U.S. forces, were never charged with any crime. They were arrested for the most part to be used as what the Army calls bargaining chips, because they had some kind of relationship to some man who was wanted, husband, boyfriend, brother, whatever. That's another way of saying that is that they were taken hostage. And it's against international law, to arrest somebody in order to try to pressure a third person, to turn themselves in. But that's exactly standard procedure. And again, this is something that U.S. military officials, stand up at a briefing and just say. The fact that it's against international law is, it's as though that's just a parallel universe that they have no obligation towards. So, again, I want to just, I'm so thankful for CCR and that somebody is taking that on.